over the span of these three series, we have tried to bring in various Dalit rights activists, advocates, and law professionals to understand the nitty-gritties and also the intricacies of the Supreme Court judgment. So, for this is the series two of the three-part series. So, the National Alliance for Justice and Accountability Rights is an initiative of the National Alliance for People's Movement, a 3 decades old platform of movements collectivizing progressive legal professionals for democratic causes and solidarity with people's movement across the country. Najar has been conceptualized as a united and vital platform for practicing lawyers, law researchers, law students, and law graduates. Najar seeks to pursue causes of social, ecological equity, justice, and safeguarding of constitutional rights to provide critical legal support and solidarity to people's movement. Now, moving ahead, I'll like to introduce the moderator for the session today, Mr. Naveen Gautam. Naveen Gautam is a socio-legal researcher and has been working as a Dalit Adivasi rights activist and a social justice lawyer since past 7 years. And as is committed towards advancing the rights of Dalits and Adivasis as well as constitutional literacy. Naveen Gautam has been actively involved in grassroots movements, community organizing, and policy advocacy. He is presently involved in global advocacy and research on communities discriminated on work and dissent. I would like to hand over the platform to Naveen Gautam now.
Thank you, Khalil. Am I audible?
Yes, yes.
Okay, thank you. Thank you. So, Jai Bhim, Johar, Zindabad, Sathiyo. So, there has been little issues with the previous moderator, as you might have seen some of the face on the flyer, but I'm somebody else. In fact, the person who was supposed to actually lead this, Miss Sanjana Meshram, faced some issues, so she couldn't join, and hence we will be taking it forward. And also Disha also couldn't join because of some issues. So we'll just have Ashwini and Shiv Sundarji with us. So I think last time also we kind of had this very good discussion wherein Rais Mohammed from Tamil Nadu, Ashna from Bangalore, and then we have also had Arvind, who kind of they gave their own different perspectives. Arvind was more about discussing about what are the constitutional and legal jurisprudence attached to the whole judgment, and then Ashna presented a very strong view, very strong perspective on how the one of the judges who very specifically kind of talked about sanitization of caste and referred to all Vedas and Bhagavad Gita, and so that was another version which was presented. And of course, thanking Rais for bringing up a very strong grassroots experience, which kind of also impacted our own thought process at that point of time and pushed us back to think about, do we really need sub-classification, and if we do, then are we ready for this? So again, it's actually my privilege to welcome you all for this important session on sub-classification. And I mean, the same judgment which we are trying to kind of think again and again about whether we really need sub-classification. If we really do, then how do we need to do? If we don't, then what are the community voices? Is it kind of a politically motivated start? If not, then will it impact the Dalit politics in the future? Is another aspect which we will be discussing about today in the upcoming part of the webinar. And of course, the matter of sub-classification within the scheduled caste has broad implications, and not only for the communities directly affected, but also for the overall framework of affirmative actions in the country, because this judgment, and also there are few other judgments which are coming in the future, which are also linked to this judgment, which we are having. We'll need to follow it up and see how they will shape the future of affirmative actions in the country altogether. And all of us know that Dalit communities have been historically marginalized, and affirmative action policies were the ones which have kind of, played a crucial role in improving the socioeconomic conditions of the community. But this judgment again, I mean, there is one layer of creamy layer where very specifically they've talked about the creamy layer, but there is another layer of another layer of the judgment which talks about subclassification. And there is one side which says that no, subclassification needs to be done within the community. There is one side which says no, subclassification is not needed, because ultimately the whole interpretation of Article 14 and Article 341 by judges led by Chief Justice of India itself has kind of ignited that debate again, whether we really need that. And there is one side which says no, we don't need it. There is one side which says we need it because there is super marginalization going on within the communities altogether, and we need to talk about that. So let's kind of begin. Let's kind of talk about more legal reasoning and on this, and also a grassroots experience which we'll have. And of course, we will quickly have Ashwini. Ashwini is an advocate practicing High Court of Karnataka. She is a law graduate. She has done her law graduation as well as post-graduation from National Law School, Bangalore itself, and also a recipient of Vikram Singh Gold Medal for Young Leader in 2013, and Sitaram Jindal Foundation Gold Medal during her LLM in 2022. And she has worked extensively on legal arenas such as corporate law, public policies, litigation, legal activism over the past decades. And she has also been associated with several women and child rights based organizations and has worked on their projects in various capacities as a legal advisor, as an advocate, as a volunteer. And she has also recently started Dhwani Legal Trust, an organization that aspires to provide legal aid, especially to persons from poor and marginalized communities, thereby to some extent capacitating them, ensuring them that they have access to their own rights. So we welcome you, Ashwini. Jai Bhim. The floor is all yours.
Thank you. Thank you so much. How much time do I have, if I may ask, Naveen?
10 to 15 minutes. 10
All
to
right.
15.
Okay.
Because once you kind of give your inputs in the first part, then we will have questions, and then we can request you back to respond to them. So 10 to 12 minutes is also fine. Yeah, thank you.
Sir is there.
All right. So, good evening, everyone. It's very good to be here to discuss this extremely important judgment. As you all are aware by now, I will not, I mean, the 10 minutes that I have, I will not go that much into the exact interpretation that the judges have done in the judgment. However, I will try to bring in some themes which I thought were important, which the judgment either deals with or does not deal with, or deals with inadequately, right? So I'm going to do that. So, as you are aware, the principal issue before the Supreme Court, before the 7 judges bench, was whether sub-classification of scheduled castes for the purposes of reservation is constitutionally valid. Now, that was the core theme of the entire judgment. What does sub-classification mean? Till date, scheduled castes and scheduled tribes are treated as one single class. And class is important for the purposes of interpreting the rights, the entitlements, the benefits that some people receive, some persons receive, some communities receive by virtue of them being included in that class. So till now, by virtue of E.V. Chinnaya's judgment, which this judgment overrules, is that the scheduled castes form one class and scheduled tribes form one class. Now, the basis for that, I will go to the Constitution itself. If we look at Article 366, subclause 24 and 25, they define scheduled castes and scheduled tribes. 24 says scheduled castes means such castes, races, or tribes, or parts of or groups within such castes, races, or tribes as are deemed under Article 341 to be scheduled castes. There is a very similar definition for scheduled tribes, where they say means tribes, tribal communities, or parts or groups thereof. Now, the argument that E.V. Chinnaya made, which I will put down in about 4 to 5 pointers, and then I will go into what this judgment does, which is different from E.V. Chennaiah. E.V. Chennaiah says the scheduled castes form a class by themselves, which means that you cannot subdivide them into several parts. And such sub-classification would tinker with the presidential list, okay, the powers of the president to announce certain castes as scheduled tribes or scheduled castes, and hence it would violate Article 14. Now, I'm not sure how many lawyers are present in this crowd, so I will go into a little bit of that as well. Article 14, the basis is classification, right? Classification, the principles of equality is decided based on the principle that likes must be treated alike, and people who are unequal can be treated differently, right? So that's the whole, very, very simply put, the basis of Article 14. Now, E.V. Chennaiah said classification is allowed, which is why we have scheduled castes, scheduled tribes, but sub-classification would mean that we are dividing these castes even more further, and that would be a violation of Article 14. That's what E.V. Chennaiah adds. Next, it also said that the state cannot claim legislative competence to make these groups scheduled castes or scheduled tribes and basically demarcate within these groups as to who will receive benefits, right? But who should have the power to do it? It is the president, as we know, under 341, Article 341 of the Constitution. That is what E.V. Chennaiah categorically stated. What they also said is that when we look at scheduled castes as a homogeneous group, we're considering them as one class, you cannot possibly give preference to one part of the class or a minuscule population of that class. They're a class for a reason because they are all similarly situated when it comes to socially and educationally being backward, right? And hence they form one class. And it forms a homogeneous class. Now, that is the argument that E.V. Chennaiah said. What sub-classification amounts to was also discussed in the judgment, and they said it amounts to something called micro-classification. And micro-classification is not permissible under Article 14, which is because it affects the basic structure of the Constitution, and hence you cannot sub-classify, you cannot subdivide this entire class. So I'll end with that in terms of what E.V. Chennaiah did. They said that states cannot interfere with the power of the president to notify scheduled castes, scheduled tribes, number one. Number two, they said each of these scheduled caste and scheduled tribe is a homogeneous group, and hence you cannot further divide them. Okay, so that's E.V. Chennaiah. Now, fast forward to this judgment, right? And what does this judgment say? It says several things, like the issues before this 7-judge bench was one, whether subclassification of a reserved class is permissible under Articles 14 and 15 and 16, whether scheduled castes constitute a homogeneous group or a heterogeneous group, whether Article 341 creates a homogeneous class by creating this deeming fiction of who scheduled castes are and who scheduled tribes are. And fourth, okay, assuming that there is subclassification, what are the limits to this subclassification? Right, so these were the issues that this judgment dealt with. Now, before I go into these issues itself, I'd like to bring in some context in terms of the reservation policies itself. As my thesis in my master's was to do with the EWS reservation, I also had a look at all the Constituent Assembly debates when it came to the basis for reservations and affirmative action in India itself, right? I'd like to start off there because I think everything else flows from there. Affirmative action in terms of how we see it, this is again my opinion, very, very happy to be countered um, or agreed with, etc. But affirmative action in the US context is usually seen in a reparative manner, as a reparations concept, right? Because all the communities which have been, I will say, put to injustice over the years, we are trying to make amends by providing reservation, right? So that's how I would see the affirmative action in the US context. However, reservations and affirmative action in the Indian context is slightly different. I would say it is conceptualized as a right, as opposed to it being some sort of a make amends theory where we say, okay, you've been done injustice, so let's bring you back into the society, right? So in the Indian context, I would see it more as a right. So when you look at Constituent Assembly debates, focusing on articles, the current articles 14, 15, 16, I saw that there was a unanimous decision of the Constituent Assembly members to reservation, because they all agreed unanimously that certain castes were backward, quote unquote, and hence they needed to be uplifted. Now, if we look at Baba Sahib's speech at the end of that particular debate, we also see that it is not just upliftment of these societies or communities that we're going to look at, it is also their adequate representation in state services and educational institutions. Now, again, going back to some of the oldest reports on reservation, if we look at the context of Karnataka, there was a Miller's committee that was set up. This is during the British era. And what the committee did, and one of the first committees, I think, that was formally set up on this theme, what the committee did was to say that, was to study the state services and the education institutions at that point in time and say that there is a preponderance of a certain dominant caste across these state services and education institutions. And hence, there is a need to bring in other castes into it. So I'm connecting that to the Constituent Assembly debates, which very, very categorically said that there is a need to bring in adequate, proportional, even representation of marginalized communities into state services and education institutions. Now, let's keep that in mind. I would like to keep that as a background while we discuss the judgment itself. Now, when we look at the basis for reservation, I would say is the adequate representation in state services or education institutions, which need to be the focus of reservation. And of course, upliftment is a byproduct of that. Of course, there are people and communities who climb up the class ladder. However, the caste discrimination or the marginalization still remains. In my opinion, this judgment, at least three judges in this judgment have not done justice to this concept. Because we have at least three judges who say, oh, as soon as one community receives reservation, that's fine. Let only the first generation of that family receive these benefits, and after that, they are good to go. So why I'm bringing in this aspect of basis of reservation is I don't think most of the judges here have really recognized the basis, the historical and constitutional basis for reservations, which was adequate representation in state services and educational institutions. Because I will also go into why I'm saying this. When we say scheduled castes are a homogeneous group, why this problem is coming in, why this whole judgment came about, is because some communities within scheduled castes were completely marginalized. However, some communities sought some benefits and received them. Now, that is the misfortune, I think, that this judgment tried to address. However, by some judges here stating that some communities have already got a reservation, so please stop giving reservation, or even making wrong statements such as reservations were only made for some specific number of years. Dr. Ambedkar imagined it to be only some number of years. That's also a very false statement to be made in a judgment of the Supreme Court, because as all of us know, that statement was made, in fact, that's in the Constitution in the context of only political reservations, not socially, educationally backwardness based reservations. So this is what I want to bring in as a background to this discussion. As all of us know, this is a 7-judge bench judgment. And 6 of the judges have stated that subclassification of scheduled castes is constitutionally permissible. However, one, Justice Bela Trivedi, has dissented, which means she said that EV Chinaya must be upheld because it had a very rigorous set of principles and judgments that the Chinaya judgment went through and gave its decision. Right? So let me go into the meat of the judgment itself. The judgment discusses, in fact, I will go into Justice Chandrachud's judgment. He goes into very much in detail about especially in the context of the Equality Code of the Constitution, which is Articles 14, 15, 16. Earlier, this some of you might be aware, earlier the Equality Code was read in a certain manner. It said that all of us are equal, but there is this exception, which is reservation. So that was how the Equality Code was read by judges, by policy analysts, everybody. Now, thankfully and fortunately, over the years, the judicial interpretation of the Equality Code has become better and substantial in the sense that it doesn't look at the equal reservation as an exception to the equal. It looks at reservation as a means to further equality within the Equality Code. Now, when Justice Chandrachud deals with this concept, he says that, of course, it should be permissible if there are certain communities within that class, the big class of scheduled class, if there are certain backward castes into classes and much more backward classes, right? So there is a classification within the backward classes. Now, the challenge here, or rather the subject here, was whether that sub-classification of backward and very backward can be also brought into the realm of scheduled castes as a class. And Justice Chandrachud says, yes, it can. There is a need to sub-classify, although not micro-classify, but sub-classify, because without sub-classification, there could be communities within the scheduled caste bracket who are completely excluded, and hence the whole purpose of reservations will be defeated. Right now, why he says, like, however, there's a word of caution. As we are all aware, there is no real understanding of the data and the numbers when it comes to caste. Right now, that's a huge problem for all of us. And I don't know how the Supreme Court is passing these judgments without having that number in place, right? Thanks, Naveen. Yeah. So one theme that I want to bring in is also that there is this emphasis on the judgment that there needs to be a data-based understanding of caste system, of the scheduled caste, and hence the state must in fact have the duty to use data to understand which scheduled caste community is much more backward or much more forward, and hence based reservations on that. So the first theme is on EV Chinaya and subclassification itself that I mentioned. The second theme is the emphasis on data collection and how it is a duty of the state to ensure that data is collected, and only based on data, this classification or subclassification must take place. Thirdly, what I want to say is that there is a proposal for a two model subclassification that the Chief Justice has put forward. Now, I will not go into detail, but what I want to say is one of the models, what he suggests, is that the more socially backward classes are given preference to all the seats reserved under SC. That's the first model. Now, there are two versions of that. Second model is that the seats are exclusively available to certain castes, and seats which are not filled are given up to other castes, right? Other castes within the scheduled caste bracket. Now, this is my third theme. What I want to say is that there is a promise that we can use. I mean, it is doable. The models for subclassification are possible, in the sense that you can sort of understand the socio-educational backwardness basis of some communities and apply a test, again, based on quantifiable and demonstrable data to ensure that some communities are not excluded within the bracket of scheduled castes. Now, that's my third theme, and I'll leave it at that, because what I want to say is I have lots to say, because the entire judgment is about 585 pages long, but I cannot possibly go into all the themes. But these are the three themes that I want to highlight. But I want to say one thing about the dissenting judgment, and I will stop there, Naveen. That Justice Chandrachud, Justice Manoj Mishra, Justice Gawai, Justice Mittal, and Justice Sharma, I think all of them agree that Chinnaya is wrong, bad law. Okay, and that this doesn't, subclassification does not tinker with the powers of the president to make castes, scheduled castes or scheduled tribes. Now, Justice Bela Trivedi was extremely strong in her dissent, and she said that from the scheme of the constitution, if we read Article 341, if we read Articles 14, 15, 16 together, there is no way that there can be subclassification of scheduled castes or scheduled tribes, right? There's no way. Because if you try to subclassify and try to sort of subdivide these groups itself, it'll amount to colorable exercise of powers by the state, right? That's her very strong dissent. That having been said, what I believe, I know Naveen mentioned in the beginning that there are some groups within the communities who are supporting the judgment wholeheartedly, some groups who are not, right? If you were to ask, I will end with my opinion. I think that it is a very logical judgment, and I believe that subclassification is definitely important, because it is not a homogeneous group. Now, scheduled caste or scheduled tribe is not a homogeneous group, and hence there must be a scientific analysis and scientific a data-based system which helps us analyze the positionalities of most of these persons and communities before we apply the concept of reservation to them. That having been said, I'll also say that I don't know how easy it's going to be, because again, the claim is that the pie is too small. I do not believe that. I believe that the pie is large enough. It's just that we are made to believe that the pie is small. But again, the implementation of this judgment, I'm not very positive about, but I hope to see many more changes, and I hope to see a better implementation of this judgment. Thank you. I think I'll end with that.
We are back to the same debate again, and I don't know. That's why this series is becoming more interesting, because we are bringing in perspectives from different aspects. And I think even if you are in favor or even if you're not in favor, but if you are logically sounding fundamental, if we are kind of talking about more about fundamental rights, and also bringing in grassroots experience is something which finds the most important thing. And census is something, Ashwini, I think caste census, numbers, data, disaggregated data, which, I mean, we no doubt have census from 2011, but we have failed to collect disaggregated data, which is a major failure. Not only, I mean, when we talk about Dalits, it's not only about how many women, how many men are Dalits, but we also need to have data on housing. We also need to have data on, water and sanitation. We have been talking about SDGs at the global level. Oh, we are doing so well in SDGs and all, but we don't have our own disaggregated data. And of course, I think reparation is something which we need to discuss more, Ashwini. I mean, extensively, because our own community needs to understand what reparation actually is. Because, and I would also call reservation just a small part of, reparation, because there is a more discussion which we need to do around reparation, and how and what were the things which we deserve, which we have lost in the past, which needs to come back to us. What will be the process? And that's a major fight about. Based on a movement, a new movement on reparation. And I would request you, whenever you have time, let's have more discussion on reparation and have more clarity what reparation is, and let's have an understanding how reparation is similar to reservation, how reparation is different from reservation, and why do we need what stage is something which we need to have a discussion more. So second thing, fortunately, we have another judgment. We have a number of judgments on coming on Dalits. I mean, I'm speaking now neither as somebody who supports sub-classification, neither as somebody who's against sub-classification. I'm speaking as a moderator. Fortunately, we have a judgment 2 days back, if I'm not wrong, which specifically talks about, they have held that in prisons, if you kind of allot work on the basis of caste is unconstitutional. So they always mention that it's unconstitutional, that it's illegal, but it goes on for years and years, and then we have judgments coming up, and that's a major issue at the implementation level. And why it's not being implemented is something which we need to learn from the grassroots, because even we sitting over there in the AC chambers, having access to all the technologies, having discussion, having of course degrees from national law schools, national universities is a huge thing, and that's because of the accessibility of education which we have. But once it's about the grassroots, we really need to understand that, do the people at the grassroots understand that there is one Chinnaya judgment? Is there a Davinder Singh judgment? What does the judgment say? Because at the grassroots, if we don't have an understanding of, amongst the community, that if a Valmiki's, there is already this Brahmanical thing already existing in the communities within the scheduled caste also, that the hegemony has impacted them extensively. And there is also a divide seen. Even before this judgment, there was divide which was seen over there. And but I think we need to kind of ensure that even if we go for sub-classification, let's ensure that this doesn't turn into a political dispute amongst the community, because to some extent the whole Dalit movement has extensively garnered force from the unity, but also understand the marginalization at different levels socioeconomically. So thank you very much, Ashwini, for strongly bringing it up. And now I would request Shiv Sundarji, who has extensive plethora of grassroots experience. He is working in Bangalore, and he has extensive work experience, and we are really fortunate to have him, and good that we have him in this series itself. And of course, he's also renowned for his commitment to social justice and a dedicated career to amplifying the voices of Dalits. And I mean, I've also heard him a number of times. The way he kind of explains the whole aspects of power dynamics is wonderful. So very much vocal on these issues, and also on sub-categorizations. And so let's have a discussion with you. Let's have you, Sishandarji.
Yeah,
you have the floor now. Thank you.
Yeah. I broadly agree with Ashwini. I think we have met once in Ashwini. I think Nagmohan Das was in one of the discussions.
How would you say?
Yeah, in roundtable discussion, I think. Let me confess that I am. I mean, as I was introduced, having plethora of experience, not much. It's a little bit of exaggeration. I have been an activist. I have been a human rights activist, and I am sympathetic to the causes, and I am a participant observer in the whole sub-classification movement. I myself, I mean, unfortunately, does not belong to untouchable community. I am from actually a social background, which gave me a lot of privileges. But I have been participating in this movement, and I broadly agree with what Shwini has presented, her interpretation of the judgment. I want to add 2 or 3 things to that. Even among the 6 judges who have concurred with the main judgment, there is a kind of relative concurrence. Except for the main judgment, which is basically written by Chandrachud. Manoj Mishra was only, I think he didn't write anything, I suppose. All the other 4 judgments which concur, say for example, Mr. Gawai is the one person who raises the question of creamy layer very vehemently, and throughout his judgment, it is in the back of his mind is this creamy layer works throughout. And that has also actually impacted of his understanding of the sub-classification in a constitutional basis. And coming to Mittal, I think we all know Mittal was very, very reluctant. He wanted to do away with the whole question of reservation. And for the reason of having no better choice, he writes that very clearly, and he will go with the judgment. And Satish Chandra and Vikram Nath, the other 2 judges, just go by what Chandrachud says for the reservation and what Gawai says about the economic criteria, and none of them actually have come out with a constitutional basis on their own kind of interpretation. So even though this 6:1 judgment is very welcome and it has put to rest, and now that this review petition has also been dismissed, now at least a legal case has been made for the subclassification, and now it is a political question of how we are going to implement. Since the legal part has been discussed thoroughly, I think I will emphasize on the political part of it. See, the judgment itself also goes to the history and the political part of it, where it says that it is not a homogeneous class, and historically, because of the very nature of the caste system, caste is divisive by its own nature. You can make it a class of actually clubbing together similarly situated castes, but each caste is unique in its own way. And there is a kind of hierarchical untouchability suffered by the different groups which are classified under the scheduled castes also. For example, the very term scheduled caste, prior to that there was depressed class, and how depressed class were identified, and how this franchisee committee in 1936, 1937, I think, different franchisees committees had come up with their own understanding of untouchability, and some of the members of the franchisee committee uh, on record have said that there is no untouchability of the pattern that it exists in south and the west. So there should not be a depressed class classification based on untouchability. So they actually say that there are these jalchers and the mahars, where jalcher can put what is that of him to the Bhangi to the upper caste, and some are even allowed to enter some particular caste. So there is no similar experience of untouchability, even though there is untouchability is the basic criteria to club under this depressed class or scheduled caste. But even among the untouchability and the impact of that, even the judgment cites about the recent Gujarat study, where the particular group makes some 61 varieties of experience of untouchability practiced in Gujarat, which are different in different areas for that matter. So the judgment also says in Madhya Pradesh, when it says that there are untouchabilities, some groups are untouchable in 9 districts, and in other states they are not untouchables. So Karnataka has a unique case where we have some 4 touchable caste within the SC group, who are considered as scheduled caste within the Karnataka, because in 1920s, when this Miller Commission etc. was studying the socio-economic condition of the depressed classes, Korma, Korucha, Lambadi and Bovi were considered socially similar to the plight of the untouchables. They're not untouchables, but their plight is similar. So they were considered. So now, because of the historical reasons, there is a grouse that most of the opportunity that is provided by the reservation has been actually garnered by particular groups, which includes the touchable groups, and among the within the untouchable groups. Between Holayas and Madigas, which are 2 dominant castes, it is wide belief that Holayas have benefited more. And apart from Holayas and Madigas, there are Dalit nomad castes who are, say, some 23 castes, which many of these caste groups do not have a graduate in their community. That is the plight of their thing, and it has not reached them. That way, reservation itself has a very limited, even though there is, whatever available pie of the cake is there, that is also not been distributed, but the cake itself is being diminished after Modi declared that there will be minimum governance and minimum government and maximum governance. And when there is whole case of privatization of education, healthcare, etc., now even the lower middle class is one shock away from becoming below poverty line. That is the situation wherein which you won't actually avail the opportunities that is provided even by the reservation. And because of the historical reasons, of course, it is not a homogeneous community. This is the thing. But then what is the political part of the whole thing? The constitutionally, of course, the judgment has considered, constitutionally, there is a kind of solid argument, solid justification given by the Justice Chandrachud, which has answered all the 4 questions, 4 issues that was framed by him. And even Gawai actually concurs with that, apart from the economic criteria thing. This apart, I will come to the next part about this implementation, where the whole question of politics actually play. None of the major two national coalitions, UP, that is India and the NDA, have come out in favor of have declared that they would implement it. Start with BJP. August 1st, the judgment came out, and on August 12th, there was a kind of, press people asked the concerned minister, social welfare minister, and he says that we are vehemently opposed to economic criteria thing. When particularly he was asked, what about implementing internal reservation, he has declared that they have not come to a conclusion about it still. It was in August 13th. Even today, they have not come to any conclusion. And only after they were assured that they will not get back the Haryana again, they declared that they will implement internal reservation in Haryana. But they were sure that they are not going to do it. And among the 7 guarantees given by the Congress party, this internal reclassification was not in that 7 guarantees. And that apart, the NCSC, National Commission for Scheduled Caste Chairman, when some 20 prominent intellectuals had submitted to him a memorandum saying that the subclassification should not be allowed, he said that he is considering that. And the NDA partners have already, by then in August, they had said that they will go for review petition, etc. Now that review petition is dismissed. So NDA and the BJP, even though in states like Karnataka and Andhra Pradesh, they were banking to divide the Dalit votes based on the subclassification. You know that very famous this Mahanadu, not Mala Mahanadu, I think Madiga Mahanadu convention that happened in Hyderabad Nizam College grounds, where Modi came down just before the Telangana assembly elections. He came down and hugged Mandakrishna Madiga, who is the great leader of this Madiga movement also. And by that, he thought that he would get the Madiga votes, which he did not. With BJP, he could not get that. That's a different thing. But then, even by that, BJP has not come out with their decision. And Congress is playing another kind of game. In Karnataka, for example, after the judgment came out, it was Revant Reddy of that is Telangana Chief Minister and Siddaramaiah of Karnataka Chief Minister declared, both are Congress, they declared that they will be the first state to implement the subclassification. But now, by I think on November 23rd or so, the Congress, not now, August 23rd, Congress have declared that they will constitute a committee under the chairmanship of Mallikarjun Kharge, and only after that committee gives its recommendation, even the Congress governments can implement that judgment, subclassification. And this has created an anxiety among the Dalit groups, especially Madigas in Karnataka, and also Madigas. Of course, in Telangana, they have gone a step ahead. They have formed a cabinet subcommittee, and they have sought the opinions of the interested groups, which is not required. This is again a kind of delay tactics anyway. So that being the political status, the implementation part will be very, very difficult, because if you take, for example, Karnataka, what will be the criteria to subclassify? Now we have this Sadashiva Commission report, which was submitted in 2012, which had, we started from its study right from 2008, I think. You have Usha Mehra committee report, particularly about the Andhra conditions, undivided Andhra condition. You have some statistics about Tamil Nadu. I think it is based on these things. These 3 states were in the forefront, even appealing before the Supreme Court for the reclassification. But all these things pertain to the census numbers of 2001. Now it is already 25 years. So generally, the population of the Dalits and Adivasis will grow in when you compare that with the dominant caste. So if you go by the 2001 census, it will be very difficult. And within these caste groups of Dalits, different caste groups, even Sadashiva Commission could not actually release the knot where there is 3 specific things. For example, within the subcaste, we have what is called as Adi Karnataka, Adi Dravida, and Adi Andhra. Adi Karnataka is not one caste. It's a combination of 2-3 castes. Those who are considered as broadly Holaya related caste in some part of Karnataka are considered as Madiga related caste of the same AKAD. So how do you resolve this knot is one problem which some Dalit organizations which are in favor of internal reclassification also raise this issue. But then If you wait till the another census report, this will actually hang up for another 3 years. That becomes like a women reservation issue. So the larger issue is how are you going to implement where there is a favorable situation. When you compare to North India, at least in South India, there is a favorable situation for the implementation, at least in Karnataka. Tamil Nadu, in fact, had already implemented their own kind of subclassification for Arundhatiyas. Of course, there are dominant Dalit caste within the group, had also gone for the Tol Tirumavalavan was one of the petitioner for the review of this judgment, of course. But then there is no much antipathy for this subclassification, unlike the North India. In North India, I think the whole issue of understanding subclassification suffers from three major maladies. One is there is a deep politicization of the Dalit politics there, especially with the entry of the BJP into the subaltern groups, especially the Chamars and the Pasis, where the non-Chamars in the Uttar Pradesh are with BJP, and they have been, I mean, they are dividing the Dalits and also politicizing the Dalits in the Hindutva way. Second thing, even if you consider the argument made by, for example, Chandrasekhar Rao and other groups which are basically anti-BJP and who are basically for the Dalit causes, their main play is that if in some group within the Dalits are actually getting more reservation, it is not because of the dominance, it is because of the numerical dominance. Because we are more in number, that's why we are getting more reservation. It is not because of the domination or exploitation of the other groups. Second major question that they are raising is who actually asked for this subclassification? Nobody asked for this classification, and it is the suo kind of the Supreme Court. They wanted to divide the list. That's why they are doing it. Because just before the August 1st reservation, there was this lateral entry thing that had happened, and BJP is known in North India among the Dalits that they are against reservation. That's why they lost the Dalits vote in the northern part of India also. So they club this kind of this judgment with the larger BJP's design to divide the Dalits. For that, they have there is a kind of lack of information, especially about the dynamics in the Dalit among the South India. There has been a movement for subclassification among the uh, relatively deprived Dalits. For example, Madigas of Andhra and Karnataka are fighting for this for the last 30 years. So this is not a kind of suo moto action taken up by because if you look at the list of the petitioners, there are many Dalit groups who have actually appealed before the Supreme Court, and there has been a demand for this. So there are these misgivings and misunderstandings and lack of information and politicization that's happening there. So this is the larger part, and implementation definitely needs actually empirical data, another kind of analysis. And more than that, since it is a political process, implementation is not a legal process. What the constitutional the bench has done is it has actually said that constitutionally there is no bar for reclassification, subclassification of the reservation, because every political party in the government was actually taking shelter at this particular point that the constitution does not allow us, so there is a need for constitutional amendment, and the judgment says that there is no need for constitutional amendment, there is no bar for reclassification, and state has the power to reclassify. It did not say that state has to do it, because it is not a fundamental right in that sense. It is a kind of enabling right. Even reservation is considered as a enabling right. Now it is up to the states. So now it comes to the realm of politics. So when you come to the realm of politics, it is only at the first level, there should be a kind of a democratic dynamic that should happen within the scheduled caste, because largely this is a question of democratic redistribution of the limited resources. So how are we going to share that with it? Because there is a democratic aspect. Each and every oppressed movement, even though it is an identity movement, every identity movement has a demand for recognition and redistribution. And if a dominant kind of people's movement does not recognize this need for recognition and redistribution, that will provide the way to divide the existing groups for the benefit of the political class. Do we have that maturity? Do we have the people's movement have that maturity? Because this is not just a movement of the a group within the scheduled caste. This is a larger question of social justice, which pertains to the question of redistribution of the limited resources. There is a larger question of how are you going to increase the pie. In fact, day by day it is shrinking. That is the basic fact. And extend, for example, why the 50% upper limit for the whole thing? In fact, Karnataka government, the previous government, has recommended to the central government to increase the scheduled caste reservation from 15 to 17%, and scheduled tribes reservation from 3 to 7%. That has not yet been questioned in the court, because if already it's been implemented, if it is questioned in the court of law, that would be quashed because it crosses the 50% limit. When there was no upper limit for the EWS reservation, why this artificial limit for the reservation for OBCs and SCs? And there should be a united fight of OBCs and SCs to increase, to do away with this 50% upper limit. There should be a united movement of the Dalits, OBCs, and all the oppressed as a class to actually reclaim and also gain the resources of the power sharing and also the resource sharing. In fact, the whole reservation, even all the committees which has gone into the understanding of the benefits, it only suggests that hardly 2 to 3% of the oppressed communities are availing the benefits.
Shiftandaji, I'm sorry, very sorry to pause you. We'll have to quickly finish it off. Maybe last few minutes.
So I will stop at here. So we need a larger kind of unity. It's a political process. Political process needs democratic consciousness and especially understanding identity movement in a democratic spirit. That's it.
Perfect. Thank you, Shiv Sundarji. I think I was kind of having a discussion with Khalil about one of our speaker backed out. So how will we manage time? So I think still we need more time for both of you, and you can take it on for next 2 hours. So that's very convenient for us also, and also thanks for not backing out and bringing so much light to this discussion. I think Shiv Sundarji, one more thing which we need to ensure is, which me as a North Indian, I'm speaking as a North Indian Dalit, what I am constantly listening to and what my colleagues and other people attached to the movement are listening to is this whole aspect of politically motivated step. So they are not looking at subclassification as something which they can learn from. Point one. Point two, they don't want to learn about this subclassification because they think that, okay, now, this is a BJP oriented, but sometimes what BJP does, it tries to show that things are going against it. But the same step is actually taken by BJP itself just to set the narrative. That's what its past strategies has always been. So, but not bringing any specific political party. It's not like, it's only BJP, but even sometimes Congress is also to be blamed very extensively. If we look at the state. So more or less, it's the government which has to ensure that, implementation takes place, but that implementation has to reach the ground, Sundarji. And I think that's the point you are also constantly talking about, is how do we ensure that the knowledge about the judgment, specifically subclassification, reaches on the ground so that they actually understand that, okay, this is the reason why we need just subclassification. It's not like we are trying to snatch away somebody's right. It's just like we are trying to ensure that there is equity. We keep talking about equality and equity. It's to show that there is equity amongst the scheduled caste community, which itself is not a homogeneous group, as you and Ashwini have been talking about. So yeah, I mean, I won't take much time. We are already taken 1 hour. So I'll quickly invite questions. Maybe if anybody has any questions or a feedback, you can write in the chat box, or you can also ask this. And I'll also request Khalil to maybe take over for next 10 to 20 minutes. Chaitanya,
I just
you
have
there?
a quick question if it is allowed.
Yeah, Chaitanya, you take over. Okay, Veena ji, yes, you can. Please.
Yeah, thank you so much. It was such a lovely session to listen to. Very insightful. My quick question for you guys is religious polarization, which has been going on in the news for past since almost a decade now, is that what is the impact for the Dalit movement? Is it working for it or against it, or is it like the real issues, which is the Dalit movement or the equality, been subsided because of such religious polarization, which takes away the most of the media time or discussion time?
Who's the question for? Is it for Shiv Sundar sir or me?
Ashwini, I don't know. Anybody can take it.
Ashwini?
Yes, sir. I will start off, and of course, you can please, given the more
Sure.
precious on the ground perspective. Whatever I've been reading, and of course, seeing as a part of my work of legal aid, right, is that there's a very close nexus of religion and caste. Of course, there's no denying it. I don't think anyone ever denies that there's a nexus between religion and caste. Unfortunately, which is why if when we read Annihilation of Caste a number of times, that nexus is in fact in our faces, like very, very directly, because which is why Baba Sahib Ambedkar says annihilate caste, annihilate religion even, right? Because but religious polarization, I don't know. I think it's a larger issue, really, in terms of again catering to the vote. I mean, the similarities I see in both the caste struggles and the religious polarization struggles are that there is a vote bank that is being catered to in both these situations, number one. And number two, there is a sort of hierarchy, the social hierarchy in both these situations, which the politics really sort of takes advantage of and tries to create these rifts. So when it comes
Correct.
to religion, of course, the Hindu majority is seen as the upper, rather the dominant community. And when it comes to caste, of course, the dominant communities versus the other communities. And
Correct.
the hierarchy is also the similarity factor that I'm seeing in both. Um, which is quite unfortunate because I think, I mean, I was just having
Yes.
a discussion with someone because in every community, in fact, if you look at the scheduled castes also, there's a hierarchy there. There is a touchable, there is an untouchable. Now, within the
Mm,
untouchables, there is a hierarchy again as to who can
mm,
do what, who cannot do what, right? Now,
mm,
that is the thing when it comes to religion also, which I'm seeing a similarity with, which I think the politics really grasps and tries to play around with. But
mm.
that I think definitely close nexus between religion and caste. I would leave it at that and ask, request Shiv Sundar sir to come in.
Yeah, this religious polarization is, of course, actually polarized even the Dalit communities. I can give you two examples. In 1984 elections, in fact, BJP got only 7% of vote. And now for the last three elections, it is consistently getting, whether it gets the equal number of seats or not, vote share is stabilized at 36%. Even this time, they got 36% vote share. This 36% is inclusive of the lower state of the OBCs and also the major chunk of the Dalits. Even though in the Uttar Pradesh they have lost a chunk of Dalit votes, the nearby state, neighboring state, Madhya Pradesh, they have increased their vote share. So how is that impacted? Even in Uttar Pradesh, for example, the Chamars are basically they are in fact consistently with the BSP. The Parsis, the other important Dalit caste within the untouchables, have been mobilized by the BJP and the Sangha Parivar. Sangha Parivar is the biggest factor. That's what some theoreticians consider this as a subaltern Hindutva, which is actually oxymoron by the name itself. But in any case, there is a kind of mobilization of the Dalits uh, on the basis of Hindutva, a kind of Savarkarite Hindutva. It is not a Goldwalkarite Hindutva. In fact, Savarkarite Hindutva says that, I mean, they would also invoke Savarkar where they say that they had actually, Savarkar had built a temple, Patita Pavan temple for exclusively Dalits, etc. He wanted to actually bring in Dalits as a part of Hindus. That was a counter to Baba Sahib Ambedkar, where in 1935 he declared that he is born as a Hindu, but he will not die as a Hindu. That's why he wanted to he was very clear that without coming out of the clutches of Hindu religion, there is no annihilation of caste is not possible. That's why he actually embraced Buddhism. But even by embracing Buddhism, he did not do away with the economic and other cultural dimensions of caste, because caste actually thrives and lives on several dimensions. One of the dimension is religious dimension. And to your question, of course, religious polarization have impacted, and in fact, the Dalit consciousness or the feminist consciousness that actually emerged in the 70s and 80s, etc., that has been completely been not completely, for a large extent, is defeated by the Hindutva consciousness that is being actually feeded into the minds of the even the oppressed caste. So that is impacting the, I mean, the liberatory kind of politics also.
Yes, sir. Thank you so much. That was my observation as well. Because initially, like, as amateur, what I'd observed, we were all focused with our community development. Now, the whole community development is gone, or it is subsided, as you said, and it is more of national development. National development of what? If I am not developed, if my community is not developed, how is national development?
Right.
Thank you, both of you, for answering that. Thank you so much.
Thank you, Ashwini and Shivsundarji for answering. Ganesh has posted a question in the chat box. Am I audible?
Yeah.
Yeah, so I will read out what he has written. He is saying, Jai Bhim, my question is, should the children of individuals such as collectors or other elites within the SC category who have already benefited significantly continue to receive reservations while more disadvantaged members of the same community do not? If yes, why? If no, is there a legal framework rather than moral self-restriction that can limit their access to these benefits, ensuring that those in greater need receive them? Any of you can start with the.
First Ashwini and next me.
Yes. So thank you for that question, because it reminded me something that I did not say, which I was very disturbed by in the judgment. Now, throughout at least three judges have spoken about creamy layer, right? Now, my perspective, my quick analysis, like when I first read the judgment, I was like, why is creamy layer coming in here at all? Because the question was not of creamy layer at all. And right. So, in fact,
Right.
look at Justice Chandrachud's judgment. It does not deal with creamy layer because the question was very different. The question was sub-classification, which is very different from the legal or the social connotations of creamy layer when it comes to OBCs or SC/STs even. Now, there are, why I'm connecting it to this question is that this whole concept of, oh, there are people who have already availed of benefits. Should they keep availing of benefits until when? Right? Now, that is a question where the Supreme Court has, of course, in a different set of cases, has dealt with whether creamy layer concept should be applied to SCs and STs. Right? But that's a whole different discussion in itself. So I was a little surprised to see at least three judges here speak about creamy layer. Like I didn't understand why it's coming in, and so vehemently opposed by the judges itself. Like on what basis are they saying? Like where are they seeing the numbers would say that these people have taken the reservation and really benefited. So let's stop it. Like where is that coming from? Right. So
Right, exactly.
yeah, that is my discomfort when I read the judgment, and I will connect it to answering this question. Again, when I started off, I spoke about the basis for reservation itself, which was adequate representation and not really economic upliftment. I will go back to that famous, popular Ambedkar, I will say, words, which says that caste system is like a tower with no staircases, right? So you're born into a staircase, and you're born into a floor, and you die there. Now, despite all the class and caste overlaps that have happened, and you see so many Dalits and so many Adivasis possibly who have gone up the class ladder, right? When we do caste sensitization, we do a lot of caste sensitization sessions in colleges nowadays, as from Dhwani. And the first question they ask is, "Oh my God, ma'am, you see so many Dalits driving Mercedes. Such a problem, right? Why are they still taking reservation?" Now, my counter to that is, what about that picture, about that Dalit driving that Mercedes is disturbing you so much, right? Like, what is disturbing about that picture is something I'm trying to understand, because that also leads me to the stereotyping of communities. When you say Dalit and you close your eyes and say Dalit, the notion that comes to the mind is dark skinned, non English speaking, ugly, say rural, struggling person. So when you see an image which does not fit within this description, you get so, I'll say, agitated. So that's what has been disturbing me also, because yes, there could be people, the classic caste divide has maybe completely overlapped in the urban areas. At least we do see Dalits who are really up the class ladder. But does that mean that we see equal number of Dalits and Adivasis as judges, as politicians, as say uh, police, the higher police persons? No, I don't see that translating. Of course, reservation has possibly helped some amount of percolation, I will say, but not really adequacy of representation, right? So to answer that question directly, I don't see, again, we need the numbers. Now if we have the numbers which say there are so many people who have gone up the class ladder, now stop reservation, I'm very happy to agree with that analysis. But still, I think the point for me, the clincher, is adequacy of representation. Now there could be people who have gone up, there could be Dalits who are driving Mercedes, there could be women, or they could be lawyers, judges who are SCs and STs. But does that really mean no discrimination up there? Does that really mean adequate representation? So I don't see that being translated. So my answer is, there is no legal framework to ensure that if you're a first generation Dalit and you've gotten all the benefits, you cannot claim them if you're second generation. There is, I mean, yes, that's a great argument to make, but please base it on a scientific analysis of the numbers, which we don't at all have. So I would say no. I would say the class caste divide is still not completely overlapped. So if you look at statistics in terms of, I mean, I can share a few articles which I've read, where if we look at Ashok Kumar's judgment also, what is merit, right? The whole tyranny of merit argument. The judgment speaks about, all the five judges speak about five different definitions of backwardness. So the question that some of the judges ask there is a student who's gotten 58% less meritorious than someone who's gotten 85%? That's the question. Objectively, we'll say yes, 58 is less than 85. But then they bring in a layer and say, what if this 58% person is a is a person who's living in a rural area, parents do not know English, has not gone to tuitions, has gone to the only government school in that taluk, right? Now you please answer, is that less meritorious? So these are the nuances I think we miss when it comes to, oh, I see one Dalit driving a Mercedes, we are sort of set, let's stop reservations. I don't, I mean, that's the disturbing sort of argument that I'm seeing. I'm very happy to agree with that if we have the right scientific analysis and the statistics to go with it. If the class mobility upwards is translating into adequate representation, I'm very happy to stop reservations. So that's my answer. Long answer, but done.
I only add two things to what Ashwini said. In fact, Justice Chandrachud have answered this question in his 165 detailed kind of dealing with the question. In fact, he poses him. In fact, the four issues framed does not have this economic criteria question. It was unnecessarily answered by the other the four judges. In fact, nevertheless, when there was this the question about in the Indra Sahini judgment, the creamy layer was applied to only OBCs, and it has very words which had spelled out that will not apply to scheduled caste. In fact, he elaborates on that. He says that what is economic criteria? What does it mean? That a particular family or a particular individual, because of the historical reasons, he has now the capability to go along with the general merit, socially, economically, and educationally. And he raises this question: educationally and economically, there may be a possibility whether it is possible in the Indian caste system for any scheduled caste person to go socially, becoming equal with the uh, upper caste. Upper caste is not the correct word to say. The Brahmins are the dominant caste. So that being the case, the general category, considering the Dalits under the general category, is a very problematic issue in the caste-ridden society. But nevertheless, the question raised by you, when there is a kind of competition between one two Dalits, one Dalit who is relatively rich, educated, privileged, and another Dalit who has not that possibility, who has not that privilege. Among them, whom do you give? Whether the class criteria should be applied to that or not. In a hypothetical case, in a case which is not actually practical, that would happen. I would just ask this question. Say, for example, there is a few posts reserved for the Dalits in the IAS examination. And we presuppose a municipal worker's son and a IAS officer's son competing. This is it is only possible in stories, because a municipal worker's son cannot even pass SSLC, cannot even pass PUC, cannot even come to Delhi to get the private tuition to actually compete in the IAS examination. Then comes the question what Ashwini raised, that is about the adequate representation. In fact, Justice Chandrachud deals with this in some more detail. It is not just adequate representation. He says it should be effective representation. For example, there are 1,000 jobs, class A, B, C, D, 1,000 jobs put together. Now that Dalits again will get 250 jobs in class D, and the others will get class A, B, C. This is replication of the Varnashrama again, even in the name of reservation. He says even it should be effective representation in class A, class B, class C, class D. So if you have to become a class A promotee, you should be there in class B. So if you are not exist in the class B, that will be opened up for the general merit. That's what is happening. The whole conspiracy of backlog, the whole issue of opening did not find suitable candidate. It is a whole conspiracy, because suitable candidate, it is only a privilege of a class within the scheduled caste. It has not actually percolated. So to answer this question, where everyone will get equal opportunity, that should be the aim. I think the problem with making reservation as the issue and the only issue is problematic. Reservation is one minuscule instrument of going towards social justice. It is not the end all, because as I said before also, it is only 2 to 3% of the Dalit population, they are getting the benefits of reservation. What about 97%? It is not possible to provide equal social justice through reservation. It is possible through redistribution of the resources, national resources. That is a larger, a political question of reordering the whole socio-economic system. In fact, that I think we should lead to that question. I think your question should lead to that answer, and even the movement of reservation should also take up that question.
Right. Thank you, Shiv Sundarji. So taking forward your what you said about the implementation question, I would also like to ask, and I would take up another comment that Prachi has posted in the chat box. So my question is that when we talk about implementation and when we talk about sub-classification, this question has never turned up about the adequate representation, that um, the seats are or the positions are left vacant after even examination happens, right? So for example, let's take the positions of teachers in colleges. They are left vacant even after examination happens, and reservation only can it is an only entrance. It can only make you stand till the enter door of examinations, right? Um, and then this argument has been given that no suitable candidate has been found. But so in this light, is sub-classification the proposed two models? The first model being the more socially backward classes should be given preference, or the second model that some seats should be reserved? How will this be implemented, even if the current classes or the current caste who can avail these facilities are also not being given position of uh, jobs or teaching positions, or are filled in the employment or education sector?
Shall we go in the same order? Ashwini?
No, I have nothing more to say. So I will just repeat maybe what I said in the previous answer because you're right. I mean, I don't see that percolating into the state services and the education system at all. So I don't know where this thing is coming of stopping reservation, etc. So again, going back to Justice Chandrachud's concept of substantial equality, like it should not just be a formal equality, but substantive equality. Sorry. So that's the whole concept. I think I will leave Sir to answer that in detail.
Yeah, the thing is, that's why there is a big movement among the OBCs and also among the scheduled castes for filling up the backlog. Filling up the backlog is a very important moment to see. This is a ploy to see that the backlog is opened up to the general merit. That's happening. In fact, not only in the case that you suggest in the North India, in all the states, especially when the private, that is aided private institutions are notorious to make this actually injustice to the causes. So we should actually demand for filling up the backlog with a rider that if there is no suitable candidate, it should never actually opened up to the general merit. In fact, in the subclassification judgment, they have suggested one thing. If within the subclassified group, a suitable candidate is not arrived, that should be opened up to another scheduled caste within the scheduled caste group. That can be allowed, but never, it should never be allowed for the um, actually the general merit. But you cannot actually discuss this in isolation also. This is very, very, very important when we discuss about reservation. What is happening in the other realms and domains? In fact, the privatization of education, privatization of healthcare, diminishing of the government machinery, etc. Actually, it is making impossible for the deprived communities to even get minimum education. So unless we also address this question, unless you make them eligible, capable, that's what Amartya says, the capabilities to actually avail the reservation has been diminished, has been curtailed very. This whole neoliberalism is all about that. So unless the social justice movement actually takes into this their perception and the conception and the agendas and strategies, even this as important as reservation, there is no immediate solution. We can until that we can continue with a very strong pressure to fill the backlogs, and it should not be opened up to the general merit. These two things should be demanded, and we should make that as early as possible. In fact, in the Rohit Vemula case, after the Rohit Vemula's institutional murder, in fact, Sukhdev Thorat had come out with a one possible solution in the university education, having a 0 year. If there are some, for example, English or for example computer, there can be a 0 year with all the scholarship, etc., to make them capable of actually competing with that. If there is a lacuna in that thing, but we cannot actually discuss in isolation with socio-economic realities. Reservation is one minuscule thing, and here also there should be social justice principle applied. This reservation judgment has only clarified that subclassification is part of the social justice phase of the constitution, equality code, as Ashwini put it.
Right. Thank you, sir. Okay, so there has been one. Ashwini has replied. So I will read out. Prachi has said something. The first point she is saying that what are the panelists' suggestions for raising awareness about the subclassification judgment and its implications? And second is which books provide a comprehensive understanding of Dr. B.R. Ambedkar's views on reservation policies? So I think the links and the suggestions can be um, put up on the Najar group or through someone, and then we can forward it. Maybe we'll have 3 more minutes for any oral suggestions.
On the first question of raising awareness about the implications of this judgment, I'm not sure I'm aware as well of what the implications of the judgment are really. But what I want to add here is that on caste itself, like that's something we are doing as our organization, like to speak about caste, because speaking about caste usually never happens in universities, and which is what is leading to all these institutional murders, right? So we try to do all these caste sensitization sessions. We don't go into reservation at all because as soon as we go into reservation, it'll become a fight and they will not listen to us. So we go into the question of discrimination. So we start off like that very slowly and then say, no discrimination. How can we create a safe space on your campus? How can you support, say, a Dalit or an Adivasi student? How can you ensure that you're using the right terminology? Like Sir said, upper caste, lower caste does not sound right. You should say dominant caste, marginalized caste, right? So we are doing this little work, but there is so much work to do. So in terms of the judgment, really, I am only not sure of the implications. But in terms of caste sensitization, I think it's important that people who are in the space go up to young people, because I don't know if we have much hope in the other generations. But going up to young people and talking about a better future and a more equal and egalitarian society, I think that's something we're trying. But there's so much to do, of course. Yes, that's what I wanted to say on Prachi's first question.
Um,
I, I don't
I
have a
think
question per, per se, but thank you so much.
just Kamni, please wrap up as soon as in 2 minutes.
No. I'll wrap up in a minute. Thank you so much for the conversation, because even in the trans movement, we are grappling with the demand for horizontal reservations. And although not directly linked, uh, what Sir said and what Ashwini ma'am you said was very important and very useful for us. When you said about effective representation, I was like, oh my God, we have never even incorporated that in our demands. Thank you so much for that. That's all. Thank you.
Thank you, everyone. I think we'll wrap up here. And on the behalf of Najar, I would like to give a vote of thanks for the panelists, Ashwini and Shivsundar ji, and all the participants. Thank you for giving us your time. We'll hope to see you again, and let's carry on these conversations, important conversations. Right. Thank you. Thank you for coming.
Thank you. Thank you for it.
Thank you.